listened to Ms. Groff's testimony yesterday, correct?
Yes.
Did you hear her discussion of the position of Joe Ryan and the blood, whatever she called it, on Joe Ryan? Do you remember that discussion?
Yeah, you mean specific to his arm? Or is that what you're referring
Specific
to?
to his position on the ground.
Yes, I did hear her talk
Okay.
about that.
Did you agree with that?
That the blood stains would indicate that he was lying on the ground?
Yes.
No.
And what can you point to in your expertise that would have you arrive at that conclusion?
Well, so I guess starting with, I believe that she mentioned that the stains that were the 4 linear stains that I did not classify, she classified them. So that's where the first divergence was. So then that classification is what led her to say that he would have been in a position lying on the ground when they were deposited, if I recall correctly. So the first part is that as I mentioned before lunch, the target surface didn't lend to classification to start with, and to go on to then determine what that classification would mean in terms of his positioning is the part where it starts by the fact that I didn't believe that a classification could be made. Then to go on further to say what that classification would mean would be why I would disagree.
Okay. And was there evidence that you observed that would have supported different conclusions than that, other than not being able to classify?
So maybe the best way to describe this is to have you understand what a drip stain is in terms of bloodstain pattern analysis. A drip stain is a stain that is formed by gravity alone. So it's not just a circular stain you see on a surface. It's a circular stain that arrived by a passive formed by gravity. So it's not something that happened that's circular from another mechanism, but it just happened to hit the ground at perpendicular, making it circular. It is formed only through gravity alone. So the fact that I didn't classify it as anything was the first part. But then on top of that, if you have just the fact that something is circular does not make it a drip stain. It's one of the features you can look at, but it doesn't mean that it's a drip stain. So there are other mechanisms that when the blood is going through the air, say from an impact, say somebody was being beaten with a hammer. When the blood goes through the air, it goes in a parabolic arc, and if it doesn't hit anything in that trajectory, it will eventually fall to the ground, and when it hits the ground, it's going to look circular. But if it hits the wall on the vertical surface, it's going to look circular there too, because anywhere it hits a perpendicular, it will look circular. But we look at the size of them to kind of help to inform whether it could just be a drip stain, something that just was because somebody was standing over something and dripping blood, or if it was because of another mechanism. So because we didn't have a lot of these features, there was no classification done, because the size helps to inform that, and then the shape itself and the fact that we had this target surface to eliminate any of those other mechanisms, to only say that these are coming from drip stains and coming from above was part of the problem. Going further, if they were drip stains, it doesn't mean that because his arm was this way that he was down on the ground. It just means that the arm was in a position horizontal to where the passive drop was coming. Because people move around, your arm can be your body can be in different positions when you do that. So the orientation of your body and where that is in relation to where the blood is coming from is going to be how it will look like on that surface. But it's hard to then say, oh, the person was in this position just because there's something circular here that I think is a drip stain, and therefore because it's coming from above, he has to be on the ground lying down.
And if you were, as you've indicated in your previous testimony, that you would need more information, what more would you need other than what you just said in order to even make the determination?
Judge, objection calls for speculation.
You mean what? I'm sorry.
Objection calls for speculation.
I'm just asking her what other tools.
Overruled, that's fine.
Yeah, I think, I mentioned earlier, same answers as I would be looking at the size, shape, distribution, location, appearance. Those are the features that I look for and determine that this is a drip stain to the exclusion of all other mechanisms. I would want to look for something that would look perfectly circular, that I could see scalloping all around the edges or spining around the edges, or it's perfectly circular on, like, say, a smooth surface, and that it has some size to it that would indicate that it's coming from just gravity forming it. If it's tiny, then, and I see it in terms of other, maybe in terms of other spatter stains in that area, I'm going to presume it's coming from, or classify it as something coming from a mechanism that's a spatter-producing mechanism, as opposed to just a single passive drop. So sometimes we can't tell. I mean, you know, we just have to look for those features and hope that if the target surface allows for it, we can classify it.
And in the absence of concrete information, is it appropriate to default toward a
Objection leading.
classification?
Sustained as to leading.
In the absence of additional information you want, how does one resolve that?
You go back to the higher classification. So if we start at blood stain, and then we might go to a spatter-producing mechanism of some sort, and then we can classify that either to cast off or impact or expirated blood. If we don't have the features to meet those on each level of that, we revert back to the level that's higher. And so in this case, I just said, these are blood stains, and I described them. They were irregularly shaped, somewhat three-dimensional on the arm.
Okay, thank you. I have no further questions.
All right, cross-examination.
Good afternoon, ma'am.
Hi.
So to stay with where we just left off.
Okay.
You're keeping it at the classification level that's up here because you don't have enough information to go a next step. Is that correct?
Yes.
But that doesn't inherently mean that that next step isn't a possibility, right?
Well, I don't consider the possibilities, because if I can't go beyond the classification, then I didn't go beyond the classification. There's a reason I stopped.
Sure.
So I wouldn't,
But because you stopped, that then leaves all of the options still available. None have been excluded, correct?
I mean, every possible mechanism that could possibly produce a blood stain.
Yes.
Yes, I guess, yes.
Yes,
Yeah.
including drops from above.
Yes.
Okay, thank you. Going back for just a moment, you testified regarding the DLI lab, and you stated that the test sample was the pull from the genes avoiding staining. Is that correct?
I'm sorry, say that again. I didn't
You
hear that.
testified about the DLI DNA lab, specifically that the sample was a swab or a portion of Joseph Ryan's genes avoiding staining. Is that correct?
Avoiding staining, yes, I'm
Okay,
sorry.
but did you also read in the report that that sample was positive for blood?
Yeah, so it didn't say it was positive for blood. It said that blood was indicated in the sample. And so what that means is that they did a presumptive test. So that's a test that,
Right, we heard about that from our DNA experts. but-
so we didn't, the blood wasn't identified in that sample. It was an indication that there was blood there. And I think to clarify that the testing that is used in that instance is a very sensitive test that can pick up blood that you
Judge, I'm going
can't
to
see.
object. I don't think she's presented any foundation for knowledge of how the testing was conducted, and that wasn't my question.
All right, we're going to ask your question again. Let's go
Okay.
that way.
The laboratory result said that blood was indicated, yes or no?
Yes, that's not what you asked me, though. You said it was found. The test only said that blood was indicated,
Okay,
and yes.
thank you. That's all I have, Judge.
Okay, any redirect? Is this witness subject to recall?
Yes.
All right, so since you're subject to recall, just don't discuss your testimony with anybody, all right?
Okay, thank you.
Thank you.
Your Honor, if I can consult with counsel for
Yes.
just a moment.
I'm sorry.
The witness is not subject to recall.
Okay, you are not subject to recall, ma'am, so you're free to go if you wish. All right, thank you. All right, your next witness?
Yes, thank you, Your Honor. Brendan Miller.
Brendan Miller?
I need like space for my paper.
You swear or affirm to testify truthfully in this case under penalty of law. Thank you.
You don't have to go away. I can start my Miller notes. I'll scroll if I have to.
Good afternoon, Detective Miller.
Good afternoon.
Can you please state your name and spell your name for the court reporter?
Yes, my name is Brendan Miller, Brendanmiller.
And where do you currently work?
Fairfax County Police Department.
In what capacity do you work in the Fairfax County Police Department?
I'm a detective in the child exploitation section.
Okay. During your, were you involved in this case as an investigator at any point?
Yes,
Okay, and what was your capacity as investigator?
I was the digital forensics examiner for this case.
And when did that change?
About a year ago.
Sorry, almost there.
Yes, ma'am.
Court's indulgence. Wednesday. Okay, gotcha. Thank you. In child exploitation, do you utilize the same skills that you had when you were at digital forensics?
I do.
Okay. And so when you left digital forensics, did you leave of your own volition?
I did not.
And was the transfer to child exploitation?
Yes, the transfer was to child exploitation.
Okay. How long had you been in digital forensics prior to being transferred?
Since roughly 2019, so about 5 years.
Okay. And how long, how many cases had you handled in digital forensics prior to that transfer?
I don't recall the exact number.
Okay. Were you the person who did the digital forensics in the Fairfax County Police?
One of them.
How many others are there?
There were 6 at the time, I believe.
And now, when you were transferred out, this was in the middle of the investigation of this case, correct?
I don't know if I would classify it as the middle or
Okay.
where it was.
It was during the pendency of this case.
Yes, this case was still going on.
Okay. And in your capacity as digital forensics examiner, I'm going to ask you to look at a document. Judge, do you see anything on the screen?
Just your screensaver.
Okay. My apologies, Judge.
That's all right.
Sir, can you see that on the screen?
Yes, sir, I can.
Okay. Do you recognize that?
I do.
Okay, and what is that?
That is an executive summary.
And this is an executive summary that you wrote as digital forensic examiner for the Fairfax County Police?
Yes.
Did you want to mark that as a
Yes, Your
Exhibit.
Honor. 85, please. Defense
85 for the
Exhibit 85.
record? Just thank you.
And sir, this is your personal digital forensics executive summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this was related to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge, at this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is the objection, so I'll sustain that objection if you want to lay it.
I can do that.
Sure.
So, sir, tell me about your experience in digital forensics.
In what regard?
From the moment you got into digital forensics, what kind of training did you have?
I've received training in a variety of forensic tools and training specific to computer systems, specifically the International Association of Computer Investigative Specialists, IASIS. I've also been trained with Cellbrite and am current in both of those certifications, and training with Magnet and X-Ways and various other forensics platforms.
Okay. And did you receive additional training beyond that within the Fairfax County Police?
I'm also certified for BERLA, which is the vehicle forensics. Various other trainings at different times.
Have you ever been qualified as a witness in the courts of Fairfax County?
Judge, I'd
I'm
object to the question.
qualified as an expert,
There
I'm
we go.
sorry.
Yes, I have.
Okay, how many times?
2 that come to mind.
Okay, and was that in your capacity when you were a digital forensic investigator?
Yes.
Okay. Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
Now, sir, is this report the report that you created?
Yes, I wrote this.
And when was this report created?
I don't recall the exact date.
Okay. Was it prior to October 25th, 2024?
I don't recall exactly, but that sounds about the right time frame.
Okay. And that's a significant date because that was if I can remind you, the first recant for Juliana Peres Magalhães. Does that give you a better idea of when this would have been done?
If memory serves, this was done prior to that.
Okay, that's all we can rely on is your memory. And, Your Honor, I don't have any further questions.
All right. You have cross-examination?
I mean, Judge, I would note that, no, I have no questions at this
Okay.
time.
All right.
Those are all the questions,
Is
Judge.
this witness subject to recall?
Yes.
Okay, sir, since you're subject to recall, you cannot discuss your testimony with anybody. You do not need to stay here today, but just be on call for that, okay? And you're still subject to the rule of witnesses, okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Lidsky.
Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
Sir, can you please state your name and spell it for the court reporter?
Harry Lidsky, Harry, LID as in David, SKY.
And how are you currently employed?
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And what's your background in terms of digital investigations and investigations?
Prior to starting my own company, 4DIS, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature, is where we came, our services were brought to bear. On top of that, we ran our own investigations, those specifically which were digital forensics centric.
And in terms of issues, have you ever heard of catfishing?
Yes, I have.
Have you worked within investigations where it's alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
I do.
Describe for the ladies and gentlemen of the jury what that exactly is.
It's a form of misattribution in terms of who's performing what activities. So at its core, it's somebody pretending to be somebody else, usually designed to lure somebody else to do something. It can be employed in a scheme to defraud. It can be employed to get somebody to show up, to get them in trouble, to get somebody to show up to an event they had not intended to show up at. A case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case. And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
In addition to the digital forensics, again, 7 years with the DEA, it was drug law enforcement, pretty straightforward, what you'd think, what you'd expect, I guess, between the street level version of it. Domestically, always working our way up towards the source, back to the cartel sources, and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office, the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations, to the extent that makes sense. There was a number of high-profile investigations. Fast and Furious might be one of those, where our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find, we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously. Those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us, or in an investigation, somebody within within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were.
Judge, at this point in time, I think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Well,
Continue on that.
It was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of investigative experience. That added component from the OIG of having the investigative oversight and being the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted to include everything from white-collar, bribery, catfishing, international money laundering, conspiracies, and the normal type of white-collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection leading.
All right.
Explain what you did in terms of the investigation of the investigations.
Sure. DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF, U.S. Marshal Service, Bureau of Prisons, U.S. Attorney's Offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we're a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and the Marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally. So whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I'd say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Okay. Your Honor, I'd move Mr. Litsky in as an expert in the fields of digital forensics and general investigation.
All right.
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move in as for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case. What was the first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large, volume-wise hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of
In terms of a report or digital?
in terms of the data that was taken from the devices.
Yes, Your Honor, we have
Okay.
stipulated that the
So
raw
that-
data pulled from the devices does not need to have a chain of custody or
Okay, right,
foundation.
so he
linked.
can talk about the raw data from the
Correct.
devices. Okay.
Yes. And so, sir, what's the first step in your analysis of digital forensics when you get involved in the case?
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts. When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is somewhat analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be, it's binary. The data is the data. It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
Now, in terms of the digital forensics in this case, how do you arrive at certain conclusions?
So, digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami, and I look at their phone and there are artifacts that reveal location information in Miami, that is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead, that's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of location. So digital forensics is informative. I guess the if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well, and we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay. Now, in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at, after things had developed. The theory had already been assigned. Catfishing was already, Mr. Banfield had been charged already, and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As an investigator, whether I'm in my law enforcement capacity or now in my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean...
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You want to ask your question?
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple. I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I sustain the objection.
Okay.
Please answer the question.
So in terms of the items that you were just telling the jury that you review, did there come a time where you were reviewing and were able to arrive at conclusions?
Yes, I was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview, transcript information about planning that predated January 9th. So I don't just look at a time for digital forensics. It's important to look backwards for a certain relevant period to ensure that
Objection, non-responsive.
Sustain the objection.
Why would you look backward in a digital forensic analysis?
a single artifact, as we refer to them in digital forensics, it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might might help that context, right? That's relatable, and the communication after that might also help inform. So it's important to look backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence, should
Objection, non-responsive.
Sustain the
In
objection.
the context of certain behaviors that come up through the investigative process, like, for example, when someone may have had their phone and their laptop and when someone would have been away from that, are those things that you look at?
especially for events like that, what was happening immediately before the event is vital in determining attribution or who might have been performing what activity on a device.
Or saying in another way, would there be,
Objection, leading.
I haven't heard the question yet.
what would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed, from one person and used by another.
Okay, now can you see the document that's on your screen?
I see Detective Miller's executive summary.
Yes.
Yes,
Have you had an opportunity to review that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Okay, I'd move it into evidence. As
Objection,
Exhibit
Judge, it's a
85.
hearsay document at this time.
I'll sustain the objection at this time.
Detective Miller testified to it.
If you want to approach. So I'll sustain the objection.
Mr. Litsky, I'm going to go to, sorry. Can you see something on your screen there, sir?
I can.
Okay. There's evidence in this case regarding window replacement that was communicated by Juliana Peres Magalhães. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
Okay, and was this part of the information that you'd received from our discovery and the data that came from the devices?
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen. Can you, Your Honor, I'd identify this as Exhibit 86.
All right.
Can you look at Defense Exhibit 86 and explain what we're looking at here?
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, Your Honor.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
Sustain as
document.
to foundation, if you want to lay a foundation.
Sir, how did you find these documents and what processes did you use in order to find this information?
So based on the derivative evidence provided to me in discovery on this case, I analyzed this particular one. This came from Ms. Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach and I can explain further.
Are you want to approach?
Sir, what was the raw data that you used in order to get this, and what system did you use to arrive at this?
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the main Magnet program. So Magnet permits digital forensic examiners, in this case Detective Miller, to create a derivative subset of his work that is able to be open on any Windows computer. So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen, the juror, or Your Honor, we move that in as Commons or Defense
Same objection.
If we
Exhibit
could approach, please. So the objection is sustained.
Sir, did you work with the raw data that was provided by the Fairfax County Police through search warrants and other providers, things like that?
For search provider, for service providers, yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding is the complete device. Nothing is filtered out, but I wouldn't characterize it as raw data.
Your Honor, may I just request a 10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay, let's go ahead and take our afternoon recess for 15 minutes, ladies and gentlemen. And we will get right back to you. Again, don't do any outside research and don't talk to anybody, okay?
Mics are hot, Q.
All right, you have been watching the Brendan Banfield murder trial testimony continuing there. The defense took over this morning and got straight to work. We have heard from a number of witnesses already, 5 witnesses in total. We have the 5th one that was up there on the stand just now, a private investigator. Frank Salvedo is here with me to break down what we just saw. Let's start with this one. I know I got multiple questions from our colleagues. I had the question myself. We heard the prosecution kept saying object, non-responsive. What does that mean?
Essentially that the witness was going beyond what the defense attorney was asking. So if you ask someone what they had for lunch and they start talking about what they had for lunch, dinner, and a midnight snack, it's just non-responsive to the question. It was really a way for the prosecutor to kind of limit this witness's credentials and whatnot. Not really a real substantive objection, just kind of, as you saw, kind of messed up the rhythm of the back and forth between the attorney and the witness. Essentially, to put it in very plain terms, it's just a witness who talks too much and goes beyond the actual question.
Now, Frank, you and I were talking a lot while this was all unfolding. I do want to say, if anyone has questions while they're tuning in right now, you can text us at 202-895-5599, and we're going to be talking about some of what you saw and answering some of the questions for the next 15 minutes or so while the court is on break. Again, that number is there on your screen. Frank, we heard a lot of those objections coming from this coming towards this private investigator, Harry Litsky, and what he was trying to do is testify to some documents that were from Detective Miller. And a little bit about Brendan Miller, who was called to the stand. We're talking about a Fairfax County police officer. He's in the child exploitation unit now, but at the time of when this happened, so February 24th, 2023, he was a digital forensics examiner for Fairfax County Police Department. And the reason this is important is because, well, number one, he was not called by the prosecution. So something you and I had discussed earlier, kind of surprising that a lot of the crimes or the forensics investigators who were working on this case at the time when it happened were not called to the stand. The defense has made that a key talking point. Were you surprised when he got up there on the stand?
I wasn't surprised. I think Mr. Carroll had kind of previewed this, that he could be taking the stand. It was interesting the way it came out. Mr. Miller didn't look pleased that he was transferred from one unit to another unit within the police department, following his involvement in this case. Certainly the implication that the jury is left with is that he Mr. Miller reached a conclusion that perhaps was inconsistent with the prosecutor's theory now, and perhaps that's why he was moved to another unit. I am speculating, but I think that's the implication that's out there now in front of the jury panel.
Yeah, and for context, if you've been following this case, you probably know the name Brendan Miller. He's been in the headlines before. He was the police officer at the time. He was the former digital forensic examiner for Fairfax County Police. And he had analyzed dozens of devices from Christine Banfield. About 60 is the number that was shared in previous testimony. He analyzed those devices, and he concluded that Christine Banfield herself connected with Joseph Ryan on the sexual fetish website FetLife. So he was saying that he believed Christine was in control of her devices the whole time, which is not the narrative we have heard from prosecutors. And his findings were backed by the University of Alabama. They agreed with his findings. As we heard him say today, it was not his choice to be transferred or moved to a different unit. And for some context there, the exact quote he said when John Carroll asked him, "Did you leave by choice? By your choice?" He said, "I did not." Now, Fairfax County Police have said that it was not punishment. He was not moved because he was being punished. But Carroll says he believes he was. And it was because he didn't agree with Fairfax County Police Department's catfishing theory, that theory that Brenden and Juliana were pretending to be Christine to have those communications with Joseph Ryan and lure him to the home. The captain of the Major Crimes Bureau at the time, he has previously testified that he wasn't involved in Brendan Miller's transfer, even saying that he made statements that he never wanted Miller to investigate digital evidence from the Bureau again. So some important context there. And we immediately heard the prosecution objecting to things. As soon as his name was brought into the mix, he didn't say much up there. He just verified that he had some documents, he had looked at the forensics here, and that forensics evidence was submitted. Why did we not hear anything from him?
So the devil is in the details here. It looks like that Mr. Miller prepared an executive summary. I think they marked it as Defense Exhibit 85. So essentially the way exhibits work in court is that the exhibit has to be identified first and marked, and then it can be moved into evidence. Only then it can be moved into evidence. So it looks like Mr. Carroll took a couple of steps here. He had the witness identify the document. It was marked, but it was never introduced. So whether that was a misstep or intentional, I can't tell that yet. It then looks like the second witness who came on, the expert, was going to talk about that executive summary. The problem is that it hadn't been introduced into evidence. I think that's why there's a little bit of trepidation or confusion here on the defense side. It might be that Mr. Miller is called back to the stand to now just formally introduce the document. It's a little bit of form over substance here, but the prosecution's doing a nice job of objecting on procedural matters. But putting all that aside, what is the jury thinking? The prosecution can object, the defense can object, and the jury can think, wow, those are good objections, I am going to disregard that. Or the jury could be thinking, what are they hiding? What is going on here? Why don't they want me to see that report from one of the detectives involved in the case? I think Mr. Carroll's going to kind of undo any procedural missteps and be able to deal with the prosecutor's objection. I think that's why he unexpectedly asked for about a 10-minute recess in order to figure out whether he needs to recall a witness or how to properly prepare the current witness to deal with some of those conclusions. But this is a really important part of the case because the prosecutor is doing a nice job of playing a little defense here. But if Mr. Carroll is able to get over that hurdle and the jury's able to see some of that evidence, I think the jury's going to be left with the impression of, why were they trying to hide that from us?
Right. And we heard Detective Miller saying that the private investigator, Harry Litsky, saying when he was brought into the mix to kind of analyze all of these forensic elements, he had already been told, hey, this is the theory, this catfishing theory. But it's important to mention that Brendan Miller previously has said there were a ton of theories among the different investigators, and the theories all kind of focused in on that one theory once Juliana agreed to the plea deal. Because remember, Brendan was arrested, I believe, in September, and Juliana took that plea in October. She had been arrested, been behind bars for almost a full year at this point. So some interesting context there. I'm curious to see where this is all going to go. You mentioned John Carroll asked for that 10-minute recess, and the judge, they usually take a break, a 15-minute break around 3:15 or so. So she said, why don't we just go to break? Those jurors have to be confused right now. I'm sure there's a million questions running through their mind.
Jurors become creatures of habit, like we all do. They all sit usually in the same chair as they come out for each day. They go to lunch at the same time. They get their breaks at the same time. So they're thinking, like, what is going on here? It's not completely abnormal, but they're struggling, in my opinion, a little bit with the procedural objections and, like, why is their schedule being off kilter a little bit? We'll see. I think this is easily solvable, but I think Mr. Carroll's going to have to just reset himself, reset some of the evidentiary rules before he moves forward with this witness. And again, this last witness is an expert. He did work for the Drug Enforcement Agency for a while. He did work for OIG for a while within the ambit,
credentials.
within the ambit of the Department of Justice. So this is a very credible old law enforcement witness who has put in his time and apparently retired already. So he's in a good position to provide some pretty powerful expert witness testimony if the defense can get over those procedural hurdles and get it in front of the jury.
You mentioned to me they might recall Brendan Miller. Now, I didn't hear them say that Brendan Miller was subject to recall. So I have a question for you. Can you recall someone that you've cleared from the bench and said is not subject to recall?
You can. That's more of a convenience thing. In other words, does Mr. Miller have to sit outside in the hallway if you're subject to recall? It could be as simple as calling him on his cell phone and asking him to come back. I don't know exactly how the judges set the rules in this case in terms of those things. Again, that seems to be form over substance to me. If it's important for the jury to see that executive summary, or if it's important for that jury to see these upcoming exhibits, they're going to find a way to do it. And to prevent that, I think is going to be problematic. If I'm on the jury, I want to see those documents.
Yeah, there's a lot in there, and I think a lot of context for people. We do have a viewer question. This probably isn't your purview, the weather, but people want to know what's going to happen next week. We're expecting storms, possible snow. Is there potential that that could impact court on Monday? Is there a likelihood the courts would close for something like that?
If the Fairfax County government is closed, generally the courts are closed as the general rule. I would think, and this happens all the time, especially in these winter trials, you may have a day, a Monday, maybe a Tuesday off. But again, the jury's instructed, don't do any independent research, don't do anything. It's nothing different than a long weekend. But I see this trial wrapping up fairly quickly and certainly much shorter than the 3 to 4 weeks that everybody talked about in the beginning.
Yeah, he's already on his 5th witness. I'm curious to see who else he has up his sleeve. Any thoughts? I know you and I were talking about, we thought maybe a Fairfax County police officer was about to get called, and sure enough, we saw that happened. Is there anyone else that's sticking out for you? I know initially we talked about the possibility of Brendan's mother, Tess Banfield, being called to the stand, and Matthew has told us in the courtroom, Tess has not been in the courtroom. Do you think she would be called by the defense?
I think he's wrapping up here. I think this was anticipated to be a long witness. If he can get over those procedural obstacles, I think this may be his final witness. This may be the final wrap-up of the entire case, unless the prosecution does some rebuttal testimony.
Okay, so when we come back, to court, we're going to have the same gentleman up on the stand, Harry Litsky, a private investigator. And where we left off with him was that he had been the person who was reviewing the forensic evidence. He said he reviewed Christine's devices, and not just her devices. He reviewed the interviews with witnesses. He also reviewed her social media of all of those involved, WhatsApp, crime scene photos, all kinds of different things, and said he was mainly focused on January 9th to February 24th of 2023. And I think it's important for some context there. January 9th is the date that I believe Juliana testified is when they came up with that initial profile. They made the profile for Christine Banfield. That's according to Juliana's earlier testimony. So I would have to guess that's what that January 9th date was.
Exactly.
He also talked a little bit about the window conversation. We remember the man who testified about the windows, and he talked about, he was asked specific questions, but he kind of testified on his own accord and said, most people settle for double pane windows. You only get triple pane windows if you really want it to be soundproof. He kind of alluded to that. While he did say Brendan Banfield didn't specifically say, I want soundproof windows, but he alluded to it. What do you think the relevance there is for Harry Litsky? Why would he be looking at that conversation?
He's looking at that conversation to see maybe if Miss Banfield was involved with that window situation, whether she had agreed or anticipated or started any conversation with, we'll call him the window man.
Yeah.
The window man is kind of, again, a little bit of a red herring in this case. It seems like triple pane windows, that's very ominous. That sounds like, oh, we want to prevent any conversations, any sounds coming out, emanating from this house. If the prosecutor's theory is correct, that this was a setup and there was going to be gunshots and whatnot, and then 911 was called pretty much right away, like who cares whether it's double pane or triple pane windows?
Right.
So that seems to me like not something the jury is going to focus on. Maybe one or two jurors might think that the window man is the critical part in this case. I don't see that happening. But I think his forensic analysis goes back to who is involved in that decision making about the windows. But that decision making seems like a tangential factor in the case.
Yeah, I'm curious what direction they're going to go with that, being that Juliana was saying she wasn't really a part of the conversation, so she's kind of keeping herself out of the mix. But when we heard from the gentleman from the window factory, I believe was the company he worked for, he talked about how, he was asked directly, did you speak with Brenden or Christine for that initial order? And he said he wasn't sure. But then when he came to the home to do the look around, to give the quote, I believe is what he said he mostly dealt with Brenden. It does actually look like there's some activity going on in the courtroom. So why don't we take you back in the courtroom and we will have a recap after trial court for the day ends around 5 p.m. Frank will be back here to do a recap. Let's take you back inside.
All right, we're ready for the jury?
Yes, ma'am?
Okay. All right. See, your next question?
Judge, I don't have any further questions for Mr. Litsky.
All right.
I would ask to recall him at a later time.
Okay, well, cross-examination?
Not at this time, Your Honor, no, thank you.
Okay, all right. Sir, since you are subject to recall, do not discuss your testimony with anybody, and you may be recalled, okay? But you can have a seat. Thank you.
All right, call Detective Miller.
Detective Miller? Again? He was just sworn. Yeah, okay. Yeah, he just, perfect. He's already been sworn. All right. Detective, just a reminder, you're still under oath, okay, sir? Yes. All right, thank you.
Detective, can you see the document that you had created? Digital forensic summary? And when you obtained the data in doing your forensic analysis, describe for the ladies and gentlemen of the jury what you do.
Make sure the green button's on there.
Okay, I think it's on now. In obtaining data from a device, the first thing we do is stabilize it, and that method depends on whether it's a mobile device or a computer, whether the device is on or off. So an example of a computer, what I would do is the device, if it's already come to me in a powered off state, I would remove the hard drive, connect it to a forensic machine with a write blocker. A write blocker is a device that prevents writing to that evidence device. Therefore, no bits are changed, so no zeros, no ones, nothing gets altered. And then I take what's called a forensic image of that and create an evidence file from that, which is then loaded into another forensic tool that will parse that data and create it into a readable format for me as the examiner or anybody else to read down the road.
And would you draw your conclusions that are the conclusions that are on this digital forensics executive summary after doing that through different artifacts?
Yes, I would draw any conclusions off of data that had been obtained from a device.
Okay, and what you just described to the jury is what went into this document, the digital forensic executive summary.
Everything that was used to compile that came from data that had been extracted from the digital devices.
Okay, and specifically relating, and I'm referencing this document, January 9th, that was an important day in terms of who was using devices.
Objection,
correct?
counsel's testifying.
All right.
What's the significance of
Abstaining objection, go ahead.
Yes, what's the significance of January 9th, 2023 in this investigation?
That was a date that a Gmail account was created.
Okay, and in your investigation, were you able to determine who created that account?
Who in particular? No.
Yes. Were you able to investigate using your tools to determine artifacts such as such as other lifestyle type matters as to who was home, who could have been there, things like that?
Judge, objection is to form.
If you want to state that question again.
What are the things that, so when you're honing in on who was using a device, what things do you look at?
I would look at a variety of things. Pattern of life would be a term that would be used, but you would explore all that the data has to offer and see if there's enough artifacts there to support or provide enough information as to who may have been using that device. But barring external corroboration, it's impossible to put somebody behind a screen.
Now, in terms of reaching conclusions in digital forensics, you have to make determinations based on a number of factors, correct?
Yes.
Okay. What, if anything, did you do to arrive at the conclusion that
Objection leading?
on January 9th,
Sir, sustained as to leading.
what, if anything, did you take into consideration in arriving at your conclusion on January 9th, 2023?
For that particular date,
Yes.
I took into account all the information I had at that time as to what was the more likely scenario based on what I had at the time.
Okay. And what was your determination based upon this particular executive summary?
That based on what I had at the time, it indicated that the device owner was using the device.
Okay. Now, you've put in this summary January 17th. Is that a significant date?
Yes,
Okay. What's the significance of that date?
that was another date that an account was created.
And was that the FetLife account?
Yes.
Okay. And what's the relationship, if any, between the Gmail account that was created on January 9th and the FetLife account that was created on January 17th?
The Gmail account that had been created on January 9th was the email account that was used in the creation of the FetLife account.
Okay. And were you able to determine through your expertise who had control of the device, Christine's devices on that day?
I was able to determine that it was her phone involved in creating that device. I was able to determine that it was her phone used in the creation of that account, based on a variety of returns.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes,
Has that changed?
yes.
When did that change?
The co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so, and zeros and ones, that's binary, right?
Yes,
So your conclusions based on zeros and ones are still the same?
yes.
The only additional factor is the co-defendant adopted a different story.
I was provided additional information that had to be taken into account, yes.
Okay, meaning she told the story that she told the other day here.
Yes.
Okay. Were there any other conclusive digital artifacts that were different in the creation of this report other than the co-defendant testifying differently?
I'm sorry, can you ask the question again?
It wasn't a very artfully worded question. Were there any, so we were just talking about digital analysis, the ones and zeros, right? And that's the thing that you oftentimes work with, correct?
Yes.
And what your testimony was is that the co-defendant's testimony was the thing that changed relating to the January 17th that we were just talking about.
Yes, context is important.
Okay, and was there something other than her accepting other than her telling the story that she told that day, was there anything about the traditional digital forensics that you had analyzed that had changed?
Not that I recall.
Okay. And that was January 17th, correct? Or was it the entire report?
I was speaking to it as an aggregate.
Okay. And did you have an opportunity to be part of the questioning of Juliana Peres Magalhães?
No, I was not part of that.
Okay. Were there items within that interview that was in conflict of your findings in digital forensics?
Objection, foundation?
Are you only a foundation?
Okay. You heard the testimony, correct?
Yes,
And I'm speaking of the first time she told the story on October 25th, 2024. You heard those interviews, correct?
yes.
Okay. And so my question is, did you see conflict? What, if any, conflict did you see with your digital forensics findings and her statements on that day?
Nothing is immediately coming to mind.
Okay. Would you have seen her video where she's talking about, where Eric Klingen is asking if anybody was on FetLife on a certain day?
Yes, I've seen that.
And your knowledge of digital forensics, you knew why he was asking that.
Objection, leading?
All right, I'll sustain as to leading. You want-
Did you, in fact, did you have any idea why he asked that question?
I can't speak to why people choose to ask the questions they do in an interview.
In terms of your digital forensics findings, though, did it make sense why he asked that question?
I think it would be relevant information.
Okay. And she didn't answer it correctly, correct?
Objection, leading?
Sustain as to leading.
What, if anything, did she, strike that question.
Okay.
After you heard that she had recanted and told this story, did you see an opportunity to be involved in the questioning of her?
I think I know what you mean by that. I would have liked to have been involved, but I was not involved in questioning her at all.
Okay. Looking back on the interview, if you had been involved, could you have assisted them?
I believe so.
Okay, and who were the people that were in the interview room?
Objection, foundation?
Well, if you want to have a foundation, if he
Okay.
knows.
When she was interviewed, there were a number of detectives in there, correct?
I believe so.
Do you know any of the detectives that were in there?
Yes.
Okay, and did you have an opportunity to talk to them about your ability to assist them in her story?
Prior to that?
Yes.
No, I did not have an
Were
opportunity.
you aware that she was doing that prior to her story?
I was not aware until after it had already taken place.
Okay, so they didn't and were you the digital expert for this case at that time?
Yes.
Okay, so what, if anything, did they do to get information from you to make it a more accurate questioning of Juliana Peres Magalhães?
I wasn't able to provide them anything because I didn't know what was happening.
Okay, and no one told you that?
Correct.
Okay. The digital forensics, no, so you were transferred, correct?
Yes.
When did that occur?
Roughly a year ago.
Okay, okay, and what you're doing now is a different form of digital forensics?
Objection, asked and answered?
Overruled, I'll allow it since.
I'm using the same skill sets, yes.
Okay, but you don't get involved in cases like this anymore in digital forensics?
No.
Okay. When you were still within digital forensics, were you ever asked to change your executive summary that we've looked at?
To change it,
Yes.
I was asked to review it in light of the proffer.
Okay. Were you ever asked to go line by line and fix the conclusions?
Objection leading?
What, if anything, were you ever asked regarding your digital forensics executive summary?
To review it in light of the proffer and ensure I could explain what I had put in that executive summary.
And did you do that?
I reviewed it.
Okay. Was there a change in this document based upon that review?
Like I said, the zeros and ones did not change.
Okay. Is that why you were transferred?
I can't speak to the exact motives behind a transfer.
So, okay. So you were never told why you were transferred?
There was a discussion about the transfer, yes.
Was it related to your executive summary?
It was related to my work in the Banfield case.
Okay, and your work in the Banfield case, is it fair to say that it was,
Objection leading?
was there any other work in the Banfield case other than digital forensics for you?
For me, no.
Okay. So, let's go through that document if we can. Can you still see it?
Yes, sir.
Okay. Looking at the January 18th to until February 23rd discussions in your report. Do you stand by those same conclusions in those bullet points?
As far as the activity of the devices, yes.
Okay, and the ones and the zeros?
Yes.
And so the only thing that changes that section, and I can keep scrolling if you need to see it, is the fact that,
Judge, I'm sorry, can counsel explain where specifically in the document he's referencing?
the section of January 18th until February 23rd, 2023. Should be on the screen. I scrolled up to it.
Judge, I see a section titled 1219 to 224.
At the very top of the screen, he has the dates.
I see, thank you.
Okay,
I was just trying to include that whole
that's
section.
fine. I think she was just looking on her laptop, too.
Okay, okay. Is there anything of the ones and zeros, the binary language, that's changed in that portion of this summary?
No, the data extractions remain the same.
Okay. So the only change is that the co-defendant gave a different story.
Additional evidence came to light, yes.
Is that the additional evidence?
Yes.
Okay. Do you see the section that says February 18th, 2023?
Yes.
It says starting at 22:44 hours, Christine utilized her
Judge, I'm going to
CB.
object to reading from the document. He can question the witness.
All right. I'll sustain the objection.
Okay, do you, that statement that I was just starting to read, is that still the same?
As far as what the device was doing or the account was doing, yes.
Okay. And the only change that would change that would be that Juliana Peres Magalhães changed her story.
Yes.
Okay. Let's look at February 19th, 2023. Have you read those 3 bullet points?
Yes.
Okay. And same question. Is there anything that has changed regarding the ones and zeros, as we talked about, in that section?
No, the data remains the same.
Data remains the same. And have you ever heard the term digital forensics don't lie, people lie?
I've heard it.
Have you ever heard it?
Yes.
Okay. Now, talking about February 19th, the only thing that's changed is Juliana Peres Magalhães has changed her story, correct?
Yes, the data remains the same.
Data remains the same. 2023, 2023, February 19th, until February 24th, 2023. This references telegram communications. Do those items remain the same?
Yes, the data did not change.
Okay, so I don't want to put words in your mouth, but pretty much everything is the data hasn't changed, correct?
Correct. Context did.
Context, and the context is in the form of recantation of Juliana Peres Magalhães.
Yes.
Okay. And your conclusion? Same thing?
Yes, sir, the data still hasn't changed.
Okay, and that hasn't changed except for the recant of Juliana Peres Magalhães.
Yes.
Is that correct?
Yes.
So you were asked by the person that transferred you to go line by line and change your...
Objection calls for hearsay?
I'll sustain the objection if you want to rephrase.
Who were you asked to change your executive summary by?
Again, I don't believe I was asked to change it. I was asked to review it in light of the proffer.
Okay, and so when you reviewed it in light of for the proffer, was there ever another executive summary created after that?
No, I did not create another document.
Okay, so you just reviewed it as you were asked to do?
Correct.
But there's no actual executive summary like you did in this situation?
Correct. I did not create another document.
Other than listening to the interviews that Juliana Peres Magalhães gave, did you ever deal with her directly?
No, I had, only when I got her phone from her when she was arrested.
Okay. So is it fair to say that you were never in a position to challenge any of the things she said?
I conducted no interviews with her. That's correct.
Were you able to observe whether she was ever challenged on any of the things she said?
Only with the interviews that have been recorded.
Okay. And do you believe that she was challenged on what she was said?
Objection, I'm not sure that that is relevant. His belief,
I'll overrule as to relevance.
I'm sorry, could you ask the question again?
Do you believe she was challenged in those interviews?
I think that's a relative term. I can't speak to what the person asking the questions was thinking at the time.
Let me see if I can get us to a point where we're understanding each other. As an investigator, if you think that something may not be right, whether it's based on digital forensics or anything, you challenge them, correct?
Yes.
Okay. And that's what you would do if you were in a situation where you were interviewing based upon your work, correct?
My questions would have likely been different, but I can't speak to why somebody would ask what they would ask in an interview they're conducting.
So if somebody says something, generally, if somebody says something that's wrong, you don't challenge them?
I think I would.
Okay. In watching those interviews, were they ever challenged? Was she ever challenged?
Judge, objection calls for speculation. Again, he's testified already that he doesn't know what was in their minds when they were asking questions.
Speculation.
Well, I'm asking him about his review of the videos. It's not, it's essentially, it's his.
I'll overrule the objection. Go ahead. If you can answer.
Yeah. Re-ask the question, sir, please.
Watching the interviews of her recant, you weren't there, correct?
Yes, I was not there.
Did you think that she was challenged when she gave the story that she gave?
It appeared to be more of a free-form interview. I did not see direct confrontation on things in that interview.
Okay. And when you say free form, you mean she was just able to tell what she wanted to?
Well, they were going through the details.
Okay, so she was asked about a detail, and then she was able to give a story?
Pretty much it was a question and answer format.
Okay. And I guess my question is, I use the term challenge. Were there people questioning what she was saying?
In light of,
Any of the topics?
I don't remember anything specifically.
Okay. What were your conclusions in your executive summary that you wrote before her recant?
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner,
Christine Banfield.
I have no further questions, Your Honor.
Cross-examination.
Thank you.
Let me just put this down, or do you need it? Let me take it away.
Or just put it down. It's fine. Good afternoon, Detective Miller.
Afternoon.
All right, so you stated barring external corroboration, it's impossible to put someone behind a screen. Isn't that correct?
There needs to be corroboration of some sort, yes.
All right, and in this case, when you dug into Christine's phone, Christine's laptop, the information that you received from the external sources, Google, Apple, were you able to put someone concretely behind the screen?
At times, yes.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
Okay. And when you wrote this report that Mr. Carroll has referenced, you used the phrasing, Christine did this, Christine did that. Is that correct?
Yes.
Okay. And after additional information and further investigation, you would have changed that to Christine's phone or Christine's laptop. Is that correct?
Correct.
Because again, you can't put someone behind the screen in this case, can you?
Not for everything, correct.
Okay. The evidence itself did not change, correct?
Correct, the data did not change.
You did not change the evidence, correct?
No, I did not change the evidence.
You reviewed how many terabytes of data in this case?
A lot.
A lot, okay. And in all of that, there was no ability to reach a conclusion that one person was always operating on FetLife, was always operating on Christine's phone when interacting with the Google account that was created to manipulate the FetLife account. Is that correct?
Correct.
All right. There are no artifacts contrary to Juliana Peres Magalhães' statements regarding the creation of the account, are there?
Not that are coming to mind, no.
And the only changes that you would have made here is, again, to clarify that there are points at which you cannot tell who is operating the device.
Yes, I would have clarified. It's very difficult to speak about devices constantly saying this person's device, that person's device. I did it with Joseph Ryan's devices, Brendan Banfield's devices, Juliana's devices all throughout. I just called it the person who owned the device using.
All right, so in this case, I got louder. The digital forensics may not lie, but they didn't provide us with any conclusive evidence of who was operating Christine's phone when the Google account used in conjunction with the FetLife account was created.
Correct.
Okay. You were also asked about your review of Juliana Peres Magalhães' original proffer that occurred on October 25th. Is that correct?
Yes.
Okay. Were you aware that there was another interview with Juliana that occurred in February?
Yes.
Okay. And did you receive information from watching the October proffer about what was going on in the room between the detectives and the attorneys that were present? Did anyone show you the notes that were passed? Have you had the opportunity to talk to those individuals about what they might have whispered about when they stepped out of the room?
I did not discuss that with anybody.
Okay, so you have no idea what, if anything, went into the questions that she was asked and whether or not there was effort made to confirm that her story had additional corroboration, do you?
Correct.
Okay. Judge, I don't believe I have any other questions.
All right.
Thank you so much.
Redirect?
Sir, do you know why you as the
Could you
expert...
wait till you get to the microphone, please?
Do you know why you as the expert in digital forensics was not called in the Commonwealth's case?
I don't.
Were you ever told anything about that?
Objection calls for hearsay?
Overruled.
I just know that they were not advertising it, that they were having the proffer at that time. I found out afterwards it had already taken place.
No, I'm talking about for the trial, for this trial.
I'm sorry, ask your question again then?
So it started with, do you know why you weren't called when you were the expert in digital forensics for this case?
Again, I can't speak to somebody's motivation for not including me.
Okay. It's not a hard question to say, when you're not watching someone on a device, to say digital forensics can't conclusively determine who it is behind the device, correct?
Can you ask it again, please, sir?
Sure. It's not a hard question to ask someone like yourself, you don't know 100% who's behind that device. Isn't that correct?
Objection leading?
I'll sustain as to leading if you want to ask.
What is the likelihood of being able to say someone is using their device with 100% certainty without seeing the person?
That's difficult to do.
Okay. And that's one of the reasons why digital forensics is a valuable tool, correct?
Objection, counsel's testifying.
Overruled, if you can answer.
Yes.
And it's because of, well, the factors that you've described for the ladies and gentlemen of the jury. That's how you arrive at conclusions, correct?
Yes.
But they're not, how many times that you've arrived at successful conclusions where you were 100% certain the person who was behind the device?
I would say only in circumstances where somebody admitted that they were using the device.
Okay. Or you had a camera on them or something like that?
Correct, some kind of corroborative factor.
Okay. Do you have any idea why you were excluded from any of these meetings regarding the Juliana's recant?
I can't speak to people's motives to not including me.
Okay. Was there anyone else who was covering the digital forensics arena in your stead?
In general or for a meeting in particular?
For this case?
No, I was pretty much the one who did the analysis.
So you were the expert?
Yes.
And who would rely upon your expertise in the ongoing investigation?
The lead detectives?
Okay, and are you talking about Detective Bryant
Yes.
and Detective Goodell?
Yes.
Okay, and what was the flow of information as you found digital forensics? Did you give it to them?
Yes, everything that I processed was ultimately provided directly to Kyle Bryant and other detectives involved in the case.
And did you ever, so I'm asking in the context of like a math equation, did you ever show your work or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay, and that would be Kyle Bryant
Yes.
and Tom Goodell?
Yes.
Any other detectives?
There were a lot of people in meetings.
Okay,
About
so
this
okay, so you're talking about meetings, but did you ever go in and just talk to them in a granular level as to why you arrived at the conclusions you arrived at?
Yes.
And how often would that happen?
There were multiple occasions that I got to a granular level.
Okay. What about the command staff? Did you ever get into the granular level with the command staff on the digital forensics?
There were multiple meetings where command staff was present, and I outlined why I came to the conclusions I came to. As far as sitting down and going over every artifact, no.
Okay. And would you have been invited to do that by the command staff?
Objection calls for speculation.
I'll sustain that.
Were
Next
you-
question.
Were you ever invited to come in and give the granular details no matter who they were?
I don't recall providing granular details to command staff.
Okay. And granular, we're talking about to the nitty-gritty, right? Just so we're using the same terms.
Judge, objection is to form. I'm not sure how nitty-gritty is different from granular.
I'll sustain that objection.
How would you describe granular in the way we're talking about it?
Painstaking detail, like getting into why that artifact is the way it is, how it came to be there, going through that way. So some of them will go into that level, but not the entirety of the case, no.
Okay. And when you say some of, you're speaking to the people when you say some of them?
Yeah, there were different times throughout this investigation where I would sit down with various different people, and depending on what was desired, I would go through exactly how I arrived where I was. Some people wanted overview, some people wanted to see down to the detail.
Okay. I have no further questions, Your Honor.
All right, is this witness subject to recall again, or?
Sure, why not?
Okay, so you're still subject to recall, detective, so do not discuss your testimony with anybody, and you're still subject to the rule of witnesses, okay?
Thank you, Your Honor.
All right, thank you. You're free for today, though, I think, now. Yes? Sure. He's free for today, though, right? Yes. Okay, thank you. All right, ladies and gentlemen, we try the best intentions to get everything lined up as we can, but it appears that the defense at this point doesn't have any other witnesses that are available today. All right. So what I want to do with you is if tomorrow we can start at 9:30 and possibly go till 5:30, because I got to make up this hour because I'm chasing a snowstorm. Okay. So 9:30 to 5:30 tomorrow, if that's available for everybody. Can we do that tomorrow, 9:30 to 5:30? And I know we had talked about no Fridays. Attorneys wanted me to float with you if you were available for this Friday. If you're not, that's fine, because I told you no Fridays. But if you get back there and you can let the deputy know if all of you are available for Friday, we could do testimony on Friday. Just this snowstorm is just, I'm trying to chase it, I really am. And I want to get as much in as I could before that occurs on Saturday night. So allegedly. So we will see, but you never know around here, but I just a little concerned about it. So if you could just let the deputy know, and if you don't know tonight or you'll know by tomorrow whether or not Friday is an option, just let her know. And if it's not, I understand, because we had told you no Fridays, okay? So anyways, but you're done for tonight.
And do we risk the following week after February 6th?
No, we don't risk it. We are definitely ahead of schedule. We will have this case to you next week, depending on the snow. That's what I'm worried about, is if we get 12 inches of snow in this area, we might be out for 3 days next week, and we might not be back till Thursday or something like that. Hopefully not. Hopefully we can get the roads cleared and get you in here as quick as possible. It's my decision whether to close the courthouse, so believe me, I will be trying to get it done as we can, okay? But I just want to keep that in the ballpark, so that's why I'm trying to get the Fridays done, just in case, because I just don't know about next week, okay? But even if we come in Thursday next week, we will still be done by February 6th. I'm pretty confident in that, okay? All right, so have a good night. Don't talk to anybody about the case, and don't do any outside research, please. All right, thank you. Have a good night.